All righty. It is about 8:35, and today is Tuesday, October the 20th, 2020. Just think about it, people. 2 weeks from now, the election commercials will all end. Thank God. And maybe we can get back to seeing some normal stuff on TV. But yeah, because the third is 2 weeks from today. 2 weeks from today. Yeah, I got to do a lecture with you guys on the third, by the way. That's the only thing I'm doing working because I'm not early voting, which a lot of people I know are doing it, but I am um, traditional. I'm going to go vote on election day and go and cast my ballot. But where I live, the election place is right out my backyard, so I walk right across the yard, so I'm right there. But anyway, I don't know if there will be lines or not. So, in your area, um, are there lines? Are people early voting? Ashley, are there lines of people voting?
No, I'm
No, so people
I'm
could
not,
just. Do you have early voting in Ohio?
I honestly I'm not positive. I know where I have to go to vote.
Yeah, yeah, you're like me. You're like me. Yeah, yeah. I looked out my window. I didn't see any lines, but anyway, I go on election day, so I'll go off, pretty much focus on that. So, and then I'll be glued to the TV. Be a quick lecture on the 3rd of November. So, because actually, that will be um, that. Do you know that that week you're going to have two lectures? You're going to have That's week 5
Let me write that.
lecture on the 3rd. You're not right. That's right. That's on your calendar. You'll
Oh,
see it. I'm
okay.
going to
So
go
it's
through it.
probably I probably
Yeah,
wrote it down
yeah,
then.
yeah, yeah. We're going When we get to the calendar, you'll see it. I'm just talking about it because I'm thinking about it now. But on that the 5th, I will have the final lecture, and the reason being is because this course used to be a 6-week course, but they changed it now to a T1, T2, or 5.5, which means that the course ends on a Tuesday. So the week after the election, the 10th, that will be the last day of class. But you're going to see all of that. So let's go ahead and share my screen. But I always want to make sure I remind my students that they're not caught off guard with that. So let's see where we are here, sharing my screen. Let's scroll down. As you already know, we'll talk about this. Here's your rubric that is readily there, that you also have a copy of, and about the freedom of the press and the right to a fair trial. And you want to make sure that you follow the points in the rubric. Now, one of the things that you got to make sure is that the rubric lays out the general point system, but there are some points that aren't considered in the rubric, such as, well, they're kind of in this part here, is if you don't have a cover sheet, you lose a point. And then the other thing is that if you don't do any research, you'll lose 2 points. So that's up here. That's a okay. What's your question? Go ahead.
So I know on our case brief, I did
I know
not
what you. Yeah.
I know I did not put a cover page or a reference page because I was doing Blue Book
You,
and it's
you do
happened.
not. You do not have to do um a reference page because you just have to have the correct citation. Of course, you're going to do that if you're doing Blue Book. So you're going to have the correct court citation according to Blue Book for the citation for Map versus Ohio, right?
Yeah, I just didn't put a oh for Terry versus Ohio. I
I
didn't
mean
put
Terry
a
versus Ohio, not Map. Yes, yeah. They're two
I didn't
two
put
close
a cover
cases, though. Yeah.
page.
Uh-huh.
I didn't put a cover page on mine, but I think it's because I'm still in the mindset of
Yeah. Yeah.
for blue booking, you don't have cover pages. So
When I grade, I'm glad you said that, because when I grade this week 2, which I have not because they were just completed a couple days ago, um, when I do those, I am not going to be dogmatic about the cover sheet for the brief, but I will be dogmatic about the cover sheet for other assignments. So don't worry about that. You won't lose
oh,
a point for that.
thank you, sir.
Or the reference page. You don't have to worry about it because you don't have to have a reference page. Uh, you know, the only time you use a reference page for the brief, and you're actually telling off on yourself if you do, is that, oh, I took this information from a brief that was out there already, uh, and I took some of the language from that. We specifically said in the assignment, don't do that. You remember seeing that in there in the assignment? It's not in the rubric, but it's in the instructions for week 2. I'll show you what I'm talking about. Let's go back. Um, okay. Follow directions for briefing a case. Your assignment should be proofread. Submit. Let's see. Submit. I thought it was in here.
It's
And then I
in
saw that.
lesson content.
I was just getting ready to say that was my next place to look. Yeah, I
Yep.
know. Yeah, but I thought it was. I know it's in there because that's the idea. Yeah, it's down here. Um, yes, see in bold print. Okay, in bold print. Do not copy and paste from another source. Yeah, that's what I'm talking about. So I do run them through Grammarly to see if people are doing that. And actually, to be honest, if they give me a citation, I mean a reference at the end, then I'm more concerned about the contents of these opinions, and also you learn about the importance of this. Well, you already know, but most of your colleagues don't know this, that the concurring and dissenting opinions are critical because of new law. I've said that before, but just like um, you should be aware, if you're not, that this past week, the United States Supreme Court had a case concerning, actually it was one of your border states, Pennsylvania, about uh, mail-in ballots being counted as long as the postmark was of the day of the election, but if they arrive up to 3 days after the election, they can still be counted. Did you hear anything about that?
No, I try not to
Did you?
pay too much attention to the news because
Well, well, in this class, I always tell students, like I was talking about the issues with constitutional law in this course and Supreme Court selection and the 25th Amendment. Um, you almost reach a point where you begin to see, oh, that's actually part of my class stuff. Well, in this case, what happened, and this is what I'm getting ready to tell you, is that the decision came down 4-4 because they only have 8 justices. Justice Roberts of the United States Supreme Court, who's generally a conservative, sided with the 3 liberals of the court. And so therefore, it was a victory for the Democrats because they were saying that everybody's vote should be counted, which I think is no matter what party you're in, that should be the case. Everybody's vote should be counted as long as it's not a fraudulent vote. And so anyway, the point of the matter is that's the issue about mail-in ballots that I don't like anyway, because I don't know where they end up after I put something in the mail. So unless you send it certified mail, and you're not sending election ballots, you can't send them certified mail. So, but the point of the matter is that the United States Supreme Court played a role this week in saying that you can't do that. And so and it was 4-4, but there were 4 dissents. Now I haven't had a chance to read the opinion. I am going to read it because I like to read those things because I want to see what the rationale of those who voted against it would be. But be aware that dissents and concurrings, well, concurrings say I agree, but I don't agree for the same reason. Dissents are I don't agree at all, and this is why. But then dissents are oftentimes used to change laws in the future. So, um, just like everybody's talking about Roe v. Wade, I think I'm trying to remember off the top of my head, but I think I'm right that when Roe v. Wade was decided in the year that it was decided, and I'm looking for it so I can tell you exactly. Here we go. When Roe v. Wade came up, let's see, I think the decision was, let's see, it was 5-4. My recollection from when I was in school, I think we studied Roe v. Wade as being a 5-4 decision. Let's see, it'll tell me right here. The landmark decision, Yeah, I think it was. So what that means is when you have a 5-4, yeah, 5-4, yeah, you had 2 concurrences, no, 3 concurrences and 2 dissents. So 1, 2, 3, 4, 5. So the concurrences allowed it to pass because there were so many concurrences. But my point being is whenever you have those like close to that, one change in a justice, such as when RGB passed, in the direction that the court is going on now, you will see the possibility of a more conservative judge taking place. And as a result, the decisions are going to reflect more to the right or more of a conservative decision. So, but that's how the importance of when you're doing a brief, why we want you to make sure that you concentrate on dissenting and concurring opinions. So, but anyway, you're good. You don't have to worry about that, Ashley, because you're all right there in terms of that. All right. All right. Now, let's get down to what we're saying about this week here. So you're going to deal with the First Amendment, freedom of the press, and the right to a fair trial that the Constitution also gives to defendants. And you're going to deal with this in terms of jury selection and the First Amendment, and to determine by writing a paper, which is going to tell you how many pages when I go to the body of it, but you want to make sure that you satisfy each of these points. All right. So you are going to have a cover sheet for that because that is straight up APA. All right. Then you come down to the 3rd week. And so what you're going to do is Fourth Amendment project, relevant case law, include case briefs with proper citation. Now, here's what I have had some students to think, that you have to have 3 briefs. You do not have to have 3 briefs. You could have 2. One is even proper in your chosen area, in your chosen area that you chose during week 2, when you chose your topic in week 2. And that in writing that, you're going to have 3 secondary sources. Secondary sources, as you guys know, involves law reviews, articles, magazines, and other things. Primary sources generally are considered as statutes and the actual cases themselves. So then you're going to make sure you satisfy the number of pages. And I'm going to tell you about that in the module. Okay. Now, here we go. What I was talking about earlier. Notice it says we're at week 3 lecture. So week 5, which you'll see it better when we get to the calendar, you're going to have lectures on Tuesday night, and then the final one will take place the 5th for week 6. And then, of course, I'll have them down here. So keeping that in mind, let's go over and let's look at the course calendar. So you'll see exactly what I'm talking about. Here we come. All right. So you see, this is where we are today. Your reading assignment was given yesterday. And then, of course, you know what that is because you got the rubric. I mean, I'm sorry, you got the PowerPoints and the other information that will help you. And then your reply post is due Saturday. Your initial post is due tonight. So you only have one initial post this week. Okay. And do you know why it's only one? Do you have any idea why it's only one initial post and one reply post as opposed to 2?
My guess is because of our course project.
Nope. We had those anyway, remember?
I have no other guesses.
Okay. What are your, okay, so here are your assignments for the week that are due Sunday the 25th. Your written assignment, okay, that we just got through talking about.
Midterm exam.
There you go. There you go. There you go. I knew it come get you. That when you have exams the week, it's set up so that you only have one as opposed to 2. So that does, you'll have one this way, and then week 6 you'll have the same thing again happen. So yep, but that's what it is. So you're going to have these assignments that are due: your written assignment, your midterm exam, and then you're going to also have your Fourth Amendment project, the relevant case law. So, all right. And then if you notice, let's go to the week of the election. That is 2 weeks from today. You'll see what I'm talking about. We have a live lecture at the normal time. And then our next live lecture is 2 days later. And the reason for that, as I stated, but I want you to visually see it, is because that's the week 6 lecture there on that Thursday there. You see that on the 5th there. Okay. Is that you come to the next week and the course ends on the same day. I'm not going to give you a lecture on the day that's the last day of class. That's crazy. So that's why we're having 2. And I thought Thursday would be better than Friday to give it to you, give you as much time as possible, even though your primary assignment that you're going to be doing for that particular week will be, well, you're going to have a written assignment, but you're also going to have your posts that are due, and then your final exam. So, but anyway, the course absolutely ends on the 10th. When it was 6 weeks, it would have ended on the 15th. And if it ended on the 15th, then I would have done the lecture that way, but they changed that. So you wouldn't know about that because you didn't take the course, but I've been teaching it. So it kind of like got me, but I know what they're doing. I know why they're doing it too. So, okay. So that lays it out for you. So you clearly are on point about when these assignments are due and when the course ends. I mean to go there. I meant to go here. Down to here. So week 3 announcement is telling you we're going to deal with protecting basic freedoms, you know, like speech, press, and things of that nature. You have chapter 5 and 6 of the text along with the PowerPoints that I sent you and the additional information. There's a discussion about the First Amendment and gun control, as you should be aware that gun control has to do with what amendment? What amendment? The Second Amendment. Yeah, I don't spend a lot of time talking about it in this course. When I was teaching constitutional law, when it was an 11-week course, they had a whole 1-week module. The whole lecture, the whole readings was all about the Second Amendment. But they decided to limit that in this course, which I kind of get, in a way, because the Second Amendment is a contentious issue, and I'm going to say my position on it when we get to that section in a few minutes. But I don't ask students for their positions. Students, they in the discussion assignment, that's when you're going to see it. Okay, you'll see my position on that in my responses in your discussion post. So, but anyway, the activity First Amendment and then gun control, and then of course your initial post due tonight, 11:59 p.m. Central Standard Time, involving gun control, and then Saturday, the reply post. Finally, your written assignments back, freedom of press and right to a fair trial, Fourth Amendment, relevant case law, that's your course project, and then your midterm exam. Okay, then you know about my motto, adversity is the springboard to success. Okay, let's close that down. Okay, let's see about the assignments now, where I can go in more detail. So dealing with the course project, relevant case law, as I said, you're going to follow the rubric that I shared with you a few minutes ago that lays out how the points are broken down, but you're going to go into in depth, the topic that you chose in week 2. Should be the same one. Now, please don't switch up, because I go back and I look to see whether or not you did that or not, and do some research. I think you're kind of good at that, Ashley, but anyway, that's because you're in that paralegal training stuff that gets you prepared for it. Excellent. Case law. Yeah, I did too. I loved legal research. So much that you heard me tell my story. I taught myself how to do legal research when I was working at the law firm before they had paralegals, and so I did it manually. But yes, it is a great thing to do, particularly if you're thinking about even considering going to law school, or if you're going to be a journalist. You get into the habit of researching and things like that. So we're in a society where research is essential because things are ever changing. But anyway, yeah, yeah, it is. It is. It really is. Um, and so you're going to deal with your specific Fourth Amendment area, find some case law and secondary sources, news articles, academic journals, and so forth that deal with your amendment or the case that you chose. And you'll want to use this. Brief the cases. Now, if you have more than one case, fine, brief them. But you don't have to brief them all. But you do have to provide the right number of relevant secondary sources, which is down here for this assignment. So the cases that you brief, you'll be able to refer to them later when you write your final paper, because you're going to include them there too. So submit the case brief in proper format, which you already know how to do that. Write a synopsis about a paragraph long on at least 3 of your secondary resources. And then your paper should be, of course, proofread. And of course, you know, it's double spaced, and it is APA, because the rubric says it is. So any questions about that? Okay. Doesn't say how many pages, but you remember I said before, I said that sometimes the number of pages aren't given, but you have to determine, do you provide enough information in your assignment that a person who has no idea about what this topic is about can pick it up and read it. And then we have the freedom of the press and the right to a fair trial. It's a 1 to 2 page paper. And of course, though, make sure, as I've said this before, run your papers through Grammarly, okay, because I do. And so we deal with the Sixth Amendment and the Constitution, the right to a fair trial, and the First Amendment, where the freedom of press is. And so both of these amendments are important, but there must be an adequate balance so that in the press performing their jobs, that they are not depriving the individual of the Sixth Amendment right to a fair trial. So there are different tools that you'll discover that are utilized to try to keep that balance, such as gag orders. Do you know what a gag order is? You ever heard that before?
I have. I'm not 100% positive, but is that where, like, the media is not allowed to report on it?
Not just the media, all parties in the case, the attorneys, the defendants, the victims, are not to talk to the media about it. The judge imposes that to protect the right to a fair trial. So you're kind of you're on it, but that's what it's for, and that's one of the mechanisms that is utilized to help protect the Sixth Amendment right of the Constitution, and it's called a gag order because you don't literally have everybody uh, gag in their mouth. It just means you can't make a comment about it, because if you do, you will be in violation of the law and found in contempt of court. So you don't want to get caught in that situation. So that's just one of the tools. Another tool that, in order for a fair trial, is since we're dealing with generally juries, is the sequestration of the juror. You know what sequestering is about, right? Of the jurors.
Yeah, that's in my term, kind of keeping them locked up, um, and they don't have contact like with the
And then
outside world.
exactly, and then you monitor what they read, you monitor what shows and things like that. It's like when the infamous OJ case, that the jurors did not see the press and the accounts that the different news stations were putting out, and information that was discovered that was newsworthy until it was provided as evidence presented in that courtroom. The jurors are not tainted. So that's another way in terms of doing it. So, but you know, the issue that we deal with primarily is pre-trial publicity before one is selected for a jury. And then that's why one of the questions that's in this paper is the first one: do you believe that the press have an effect on potential jury pools and affecting the right to a fair trial? Because but see, the media has the right to report the news and information, but in order to try to balance that off, attorneys are given the opportunity to question the jurors in a procedure called voir dire, which means to seek the truth. And what you do is you ask the jurors questions and then you can ask them if they could be fair and impartial. And then you have a thing called, we talked about this, I think we did in this class. I know I talked about it in one of the classes I teach, peremptory challenges, where the jury can be excluded. Yeah, we talked about it in this class, didn't we? The Baston case, did we talk about it in this class? Where you can't use race
I'm not sure.
to
Actually, we're going over that in our cultural diversity class. I don't think we covered it in
oh,
this.
okay. Okay, I know I talked about it in one of these classes that I teach, and it might have been in criminal law because I teach that as well. But anyway, the point of the matter is that yeah, so that's one of the issues that you can't use race for excluding that. Let me put it to this way: you can, but it can't be the sole reason. It has to be other reasons. But lawyers are paid to cover what they want to do. And because of the fact that we're dealing with human beings who, is there such a thing as unconscious bias? Yes. I am part of the diversity and inclusion um, council at this school. And yeah, there's unconscious bias. We all have. But we try to not lay it aside, but regulate it so that we can be fundamentally fair, so that we don't deprive anyone of their rights. So anyway, they asked that question because that's one of the fundamental questions in the right to a fair trial is potential jury. I always ask the question, what about the judge? And you can't question just not. What we can do is we'd file motions to ask a judge to exclude him or herself because they've indicated some previous um, tendencies to want to reach a certain conclusion about a case, such as kind of like what you're hearing in the media. If you're hearing this at all, the media talk about Amy Coney Barrett going to the United States Supreme Court, and one of the reasons why the president selected her is because he wanted a jurist who would help him to accomplish overturning or doing away with the Affordable Care Act, also known as Obamacare. But the question that is asked is, can this jurist not be participating in this case because you don't want to have an unfair opportunity for the rights of individuals to be trounced upon, and or either, how should we say it, you shouldn't go in there with preconceived notions. But I always tell people the only way you can eliminate preconceived notions, such as I have been in cases where I've objected to something in the courtroom and the judge sustains my objection, but the what that means is the judge says, you were right, Mr. Wright, and then the judge would give the jurors instructions like this, and you may have heard this before: disregard those statements that were just made, and they be stricken from the record. But the court stricken from the mind of the individuals that hear him. The answer is no, unless you perform. We're going to take a recess right now while we perform lobotomies on all the jurors. That might be a violation of the Eighth Amendment and cruel and unusual punishment. So we're not going to go that far. But you get my point that I'm talking about. So anyway, that's what this paper kind of is about. I'm giving you some ideas to spend in that as well by what we're talking about now. Then the final thing that you have is about gun control. Everybody who does a discussion post for this, who does not mention the Second Amendment, is going to lose points almost without fail, because you can't deal with this issue without mentioning the words of the Second Amendment. Not necessarily the words, but that it involves the Second Amendment, as you already correctly gave us the information. And so what the legislators try to do is pass gun control, that like the Brady bill, to deal with background checks and regulation of certain types of weapons that are like some of these semi-automatic weapons, you know, that I've seen on the streets that people are able to, in open carry areas. I mean, these dudes carrying machine guns. It looks like war. It looks like you're in a war, but what's it all about? So anyway, we'll talk about that a little bit. But you're gonna initial post tonight, reply post on Saturday, and then your quiz, which is basically your midterm that you're going to deal with, and you'll have just one opportunity. It's going to be timed, and it's going to involve questions from week 1, 2, and 3. One of the best ways to prepare for this is to look at your PowerPoints and see what you've learned from them, and that will help you as well. In this course, they don't have the practice exams, so you don't have the benefit of that. In some of the classes, they do have them, and then they give you these practice exams. I don't think, let's see, did I speak? Yeah, we don't have them in here in this course, but in other classes, we do have them. Other classes you've probably taken, you've probably already seen them. Okay, so those are the assignments. Any questions about any of them? Okay. So we're going to talk about the First Amendment and gun control. And so as you are well aware of the fact that the First Amendment gives us freedom of speech. Now, freedom of speech is not exactly mean you can say anything and everything, and that there are certain things that are determined not to be protected under the First Amendment, such as obscenity, based on Miller versus California in 1973 case that we studied when I was in law school, and 413 U.S. 15, and it came out in 1973, that set the parameters out for what is considered as obscene. And any material that is distributed and is passed out that falls under any of these 4 points, these 3 points rather, then the average person applying contemporary community standards find that the work taken appeals to prurient interest. So somebody says, what's prurient interest? If you read the case, it's kind of extensive case. What prurient interest merely is that it tantalizes you or gets you into voyeurism or something like that. That is what falls within that obscenity standard for point 8. And then whether the work depicts in a patently offensive way sexual conduct specifically defined by applicable state law that states have the right to be able to regulate. And then finally, whether the work taken as a whole has no artistic or literary, political, or scientific value. Now that's usually the out that people try to utilize as a defense to materials that would fall because of Miller versus California, to say, hey, wait a minute, this third tier, there is some literary, artistic, or political or scientific value. If it just because you don't agree with it doesn't make it obscene. That's the point. So and so there it limits it. It says if a state obscenity law is thus limited, the First Amendment values are adequately protected by review of constitutional claims when necessary. So in other words, you can always bring it back to the court and they will say, because they're not going to say, oh no, we already decided that with Miller. We haven't decided that with Miller. All it did was give you some parameters and guidelines. And actually, to be honest with you, just digressing for a moment, Roe v. Wade, same thing. There's some parameters that the court laid out for Roe v. Wade dealing with abortion. So the point of the matter is it's not a blanket doing away with it. So in criminal justice, pornography is very, very, very detrimental. because it actually has to do with individuals possibly dealing with rape, incest, and then especially the child pornography aspects of it. And so, due to the fact that children need to be protected, the court determined that there is even more protection than the Miller test provides, because we want to protect our children from being, how should I say, exploited by individuals, predators, and use the children in suggestive ways sexually. So in the New York case, New York versus Ferber, the court said that the states can have more rigorous regulation when it comes to child pornography and doesn't have to rely on Miller versus California, because we want to do everything we possibly can to protect our children, which I think is essential. Very vulnerable class of individuals, and so it is so important that you can you can't your First Amendment rights are not protected there. There's a guy right now here in Illinois. His name is Harris, who is involved with some program called Cheers, and not the TV show, but Jerry Harris. He's not too far from where we live here in Naperville, Illinois, and he's in a federal court right now because of dealing with. I think that's a big news issue that I notice and pay close attention to. So it is important for you to understand that the First Amendment does not give absolute, but it does say you can generally do things, but you can't do things to incite violence. They don't talk about this a lot here. In the 11-week course, we had a section all about that. You don't do things to incite violence, or in the famous Shank case, you can't yell fire in a crowded theater. And the reason for that is because if you yell fire in a crowded theater, people are going to stampede and hurt themselves. So the Supreme Court actually had a case, Shank, I think it was Shank, that said that you can't yell that because it's an endangerment to the lives of others. So you don't have an absolute right to say things that endangers the lives of people. That's what it boils down to. And that's pretty much it for the First Amendment. There is a debate. And this is not in this course, but this is in criminal law. We talk about this. I remember that there is a right of the media to report the news, because people have a right to know what's going on in their community. And then the question comes out is, are they going too far in terms of it? Or are they reporting information that creates a danger to the rights of people who have entitled to a fair trial? In other words, provide information that reaches the point where no one can be found to give fair judgment to an individual, who commits a crime and those kinds of things. So, but it's kind of like this thing that just happened here recently with the governor of Michigan, and the case now that's being built against these individuals. And so eventually they're going to probably end up before a jury. And the question is going to be, did the pretrial information prejudice these individuals? That's what any defense attorney is going to say, that they can't get a fair trial. But here's the point. That's still not going to that's not a technicality like fruit of the poisonous tree or violating somebody's Fourth Amendment right to the Constitution, search and seizure, or violating their Sixth Amendment right to counsel, or something like that, that person's still going to have to be tried somewhere, and they're going to try to usually get into an area farther away. Like they might want to move that case out of Michigan, except that kind of case, I think anywhere in the country that it could be tried would probably uh, result in the same amount of consideration given to the trial itself. So the key thing is the media has to report stuff, has a duty to do it, and would be negligent if they did not. And so again, there's a balance between that information. And you do know that during investigations, or you may know, I teach a course where people complete a research paper, and one of the things that they do, they determine by what we call a public information officer. The public information officer is the person or individuals who give out information about the case from the perspective of law enforcement. And then there are media that's doing research. And so if you have noticed that during an ongoing case, sometimes you will hear a spokesperson for the law enforcement agency involved, or agencies involved, giving statements, and that the individuals who are investigating the case don't make statements. And the reason for that is to maintain the integrity of the investigation, as well as to protect the rights of the individuals as well. So there's a whole bunch of little things in there. So you can't get it all in 1 week in these courses, especially in 5.5 weeks. Any questions about the First Amendment and child and obscenity and any of those things? Any questions? Okay. Now, we are going to conclude dealing with the good old Second Amendment. A well-regulated militia being necessary to security of a free state, the right of the people to bear and keep arms shall not be infringed. Now, there's been a whole lot of violence going on with shootings, high school shootings. They talk about going back to Columbine, places like Sandy Hook, where former Representative Gabrielle Giffords, whose husband, by the way, is, I forget his first name, his last name is Kelly, is running for representative, or is he senator? I know he's running for a position in Arizona. And then the shooting of Trayvon Martin. And then also you have the shootings that took place in Las Vegas. And it goes on and on. The shootings at the churches, in the synagogue, Tree of Life, that took place on the military base down in Fort Hood, Texas, and down in Orlando at the nightclub a few years ago. And so it just goes on and on and on and on. And so there's a serious debate going on between people who say that the Second Amendment gives people the right to bear arms and to apply it. And so what has happened is that there has not been, of course, not a law established that says you can't have weapons. However, jurisdictions have passed laws to require FOID cards, or fire owner's identification card. I was talking to someone recently, and I don't remember who it was, and they said that in their state, I think it's Texas, they don't have a FOID card requirement. And then you have some jurisdictions are what we call open carry, which means weapons can be open. And like these individuals you saw at the Lansing courthouse, protesting the governor's decision to shut down the state with these weapons out. In our jurisdiction here, we are called a conceal, which means you have to conceal those weapons, and so you have to also keep them out of sight of people unless there's a time that you need to use it. But here's my point, is that each state, okay, here we go. Florida doesn't require, that's who it was, somebody in Florida I was talking to, does not have a FOID card. Oh, I know who it was, my daughter. I was talking to her in Georgia. They don't have one down there. She lives in Atlanta, except where the person has a concealed weapon. So each state varies. And is your state open carry, or is it carry concealed? Do you know?
I know we have carry and conceal, but I believe it's open carry. But if you want, in order to conceal the weapon, you have to have your CCW card.
Okay, wait a minute, I'm not understanding that one there. So in other words, you can carry it open
Yeah.
without a card, but if you carry it concealed, you have to have a card?
Yes.
I don't get that one. I don't get that one. But anyway, I'm saying this all to say that what various jurisdictions have done is to try to deal with a thing called gun control one way or another. The Brady Bill, which came about because of the President of the United States, Ronald Reagan, being shot by this Hinckley guy who was found to be not mentally fit, and he ended up in a mental institution for years and years. He just got out in the last couple of years. And so anyway, the point of the matter is that the guns are all over the place. That's the point I'm saying. So however you come down with weapons and guns depend upon your experience that you have. For example, me, I'm a person who's anti-gun. I had a gun only when I was a police officer. When I finished being a police officer, I got rid of my gun. But there are people who, feel like they want to keep guns in their houses. But I've also seen situations where people have been killed by members of their own family because there was a gun present. So it depends. It's going to depend on that. But let me say this. When we interpret statutes, and you will learn this if you ever go to law school, that you read the context of the statute was written for and the history of the statute. And my education as a political science major, along with going to law school, reads it as a well-regulated militia necessary to a free state. So that means, to me, military, National Guard in a state sense, or anything like that, it does not mean citizen militia. That is not what it was to security of a free state. Then it says, comma, the right of the people to keep and bear arms shall not be infringed. So the question is this written in the context of the militia, that you have a right if you're a police officer, if you're a security guard, if you're some area that you use your weapon, that you have a right to have it under the restrictions and limitations of the jurisdiction? Well, read as a whole, depends on how you want to look at that. You can't separate the last part from the first part. And if you do separate the last part, then you come to the conclusion that, oh yeah, we have an absolute right to guns and firearms. So that's pretty much the way the courts have tried to interpret it at this particular point. But let me say this. The key thing to remember is that um, they people who are Second Amendment strict constructionists of the Constitution say that even background checks infringe the right of people, because if you're a felon, you can't have one, or you shouldn't have one, or if you are a person who is mentally ill. Um, the president got rid of the law that President Obama had on the books that said that, this whole thing about people being mentally unstable and getting guns in their hands, we need to deal with that. And I agree with that. I think that it's important that if people are mentally unstable, they shouldn't have guns. They shouldn't have guns because of the fact that they will hurt themselves and or others. And so those are the things. However, good people, as we end tonight, I do want to say that, we have the best thing going now, and that is to try to um, regulate guns. I can tell you that there are people who say, well, the crooks have guns. The crooks have had guns since the beginning of time. And even with these different regulations and laws, they're still going to have guns as well. So do we want guns to protect ourselves from the police? No, no, we don't want to do that. There's some people who advocate, but we don't want to do that. That's contrary to, I think, as I say, that's kind of repugnant. All right. It's not us against the police. The police are supposed to be there to serve and protect us and are trained. And then the other thing is this, finally, when I was in the academy, they taught us how to shoot. And we would shoot with both hands. Well, most these people that you see using guns on the streets, they don't shoot with two hands. Then the other thing I will say is that when this was written, the Second Amendment, um, it didn't anticipate handguns. It dealt with rifles because that's what existed at that time. So, there's a whole lot of interpretation. So some people say, well, we contemporized the law, but okay. So anyway, but the debate goes on and on and on. I always tell my students, when you write your information, whether you complete an assignment on the Second Amendment or guns, whatever your position is, you're not going to be graded on your position, but you're going to be graded if you support your position. Don't just say, I want to have a gun because crooks have guns. That's not adequate. Give me some other reasons and back it up with some support. So, and there is no way that you can do this without mentioning the Second Amendment. So, well, I've come to the end of my road. I have nothing else to add. We're about 4 minutes over. So I'm just going to give you this one key phrase. Gun control. Give me that and you'll get your points. One last thing I do want to say, and I say this because I get calls all the time. And I said this before, but I'm going to say it again. And some people may not hear it now because I've already given the key phrase, but every Monday, I go through the grade book. And if an assignment is not turned in, I put a 0 in the book. Do not interpret that to mean that that's your final grade. It could be if you never turn it in. And if you turn in a document that's a PDF, when it says in the system that you use Word documents, we don't use PDFs in class when we do assignments because we can't edit them. We can't run them through Grammarly. I will give you a 0 and give you an opportunity to redo it. But I have had a few people to reach out to me and says, hey, I submitted my assignment on Tuesday, but I still have a 0 in there. Yeah, that's because I haven't graded them yet. But you're going to lose points, of course. But the point of the matter is when you see that 0, it is to bring to your attention that you did not do the assignment, so you can still have the opportunity. Remember the late policy rule, and I've already talked about that extensively during week 1. If you don't recall, go back and listen to it, and it'll be explained. But it's also indicated clearly in the syllabus for this class and every class that you have. So, all right, I'm going to say good night to you, Ashley. Thank you again for coming out. Enjoy your week. Again, I appreciate the help that you do as a peer mentor to the students of this university, right? We are no longer Rasmussen College. We are Rasmussen University, and all that is being worked on to change signage and stuff like that. So good night. Have a good week, and I'll see you next week at 8:30 p.m. Central Standard Time. Take care. Stay safe.